Arbor House versus Robert Gallet.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Gallet, not checked in. If you'd like to take a default, raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth to help you God.
I do, Your Honor.
Go ahead, sir.
Your Honor, this is a termination of tenancy, unauthorized occupants. At this time, requesting a default judgment. There is a second mailing with the court as well, requesting a writ date of May the 11th.
All right. Court in reviewing everything sees that everything's in order. Judgment to the plaintiff. That's by default for possession. No redemption amount. Writ issue in 10 days.
Thank you, Your Honor.
Sir.
Have a good weekend.
Thank you. You do the same. Huron Vista versus Takia Roberts.
Good morning, Your Honor. Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Good morning. Takia Roberts.
Yes.
Okay, there you are. Your camera's blocked, but okay. What is plaintiff's claim in this case?
Good morning, Your Honor. We do show that currently there is past due rent in the amount of $3,335 with court costs of $220.81 for a total due owing of $3,555.81.
All right. And Ms. Roberts?
Yes.
All right. How are you intending on getting that taken care of?
Right now I am waiting to hear back from my unemployment. My unemployment was messed up. They have to fix the dates and take some things off to get it reapproved. So I'm waiting for that to come through. And then my parents are helping me.
Hold on, slow down. You're waiting on whom to get everything adjusted?
My union rep to fix my the thing that's going on with my unemployment. They put some wrong information on there and it was basically rejected.
Gotcha.
So they have to fix it and resubmit it. And then my parents said they could help me out towards the 15th, but it will have to wait till the 15th. But I am signing up for jobs and looking. I'm also signing up for school, so I'm trying to see what my schedule would be like to have a job.
Okay.
But I'm getting help.
All right. So there's a basically unemployment compensation issue, right?
Yes.
And then that. Okay. So this is May 1st already. Okay.
Yeah.
All right. So what I will do is, ma'am, I'm going to adjourn you to my next date, which is May 8th.
Okay.
Okay. 2026 at 12 noon. Let me ask you this. In between now and then, is there anything that you can pay?
I don't have anything on me. The most that I've been able to pay is DTE because that's the most that I've been getting. As for help from family members.
All right.
Your Honor,
okay. Well, pay. Yes.
We do have a conflict on the 8th. Is it possible to get the following week?
The 15th?
Yes, Your Honor. And that would also allow time if she's able to get those.
If she's going to pay. Right. Yes. So you said your parents can help you on the 15th?
Yeah, they're looking to help me. Also, my grandparents.
Okay. All right. So what I'll do is I'll adjourn it to May 15th, 2026 at 1 p.m. That's an in-person hearing, okay?
Okay.
So you'll have to go down to the courthouse. All right. But in between then, whatever your parents or grandparents or whoever's helping you can pay, that would be great. And then we'll see where we are. Okay, Ms. Roberts?
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Have a good day.
Okay, you too. Yeah, this is short docket. Well, I'm coming in and just leaving. Gulfside Lake 3 versus Emmett Redwine.
Good morning, Your Honor. Jillian Engen for plaintiff.
Good morning. Yes. Oh, there he is. I knew I couldn't. Your name was on the docket. You were going to be here. So, how much do we have owing?
Your Honor, including May rent, I have a total balance and court costs, $4,386.49.
All right, Redwine. How are you intending on getting this paid?
I I'm gonna have, cause we get paid 5 times this month, right? Let's see. I'm gonna have 1,000 paid back by next week. I have it paid before this month is out. I can have it all paid.
All right, I got you, but let's work it this way. I'm going to adjourn you out to the 8th. Okay, so between now and next Friday, how much can you get in?
Minimum 1,000.
Okay, so about 1,000.
Yeah.
All right, so I'm going to indicate that you're going to pay that. Try to get that paid by the 7th. Okay.
It won't be if court the 8th.
Yeah, so you're going to. All right, I'll just make it the 8th. That's fine.
It'll be paid first thing that morning.
Okay, so I'll adjourn this then out to May 8th, 2026 at 3 p.m.
Okay.
Okay, and you know that's in person, so you got to be here, but get that money paid in. All right.
Yes, Your
All right. Take care. And then Sparrowwood Apartments versus Carmen Pope. That matter is dismissed on plaintiff's motion without prejudice. And I think that's the shortest think docket ever.
Can't get any shorter
That's right.
and have us still be here. So
Have a great weekend.
thank you, sir. You too.
Chestnut Landing LLC versus Martis Hall.
Good morning, Your Honor. Attorney Berta Salem on behalf of plaintiff.
All right. Good morning. And I think Miss Hall was here.
I am here. I just don't know how to turn my camera. I'm sorry.
Yeah. Okay. I'll need a camera, sir.
I don't know how to. Oh, there we go.
Got it? Okay.
Yes, sir.
Okay. What is plaintiff's claim in this case?
Your Honor, rent to retain is $10,414.25. Court costs are $191 for a total of $10,605.25.
Okay. And Mr. Hall, how are you intending on getting this paid?
So previously, my identity was stolen and like kind of messed up my bank accounts and a lot of different things, but I got all of that taken care of. I get a check in 2 weeks regarding my back pay of my paycheck that was inside of my bank account that was frozen. So I can pay either the entire thing or at least half in the next 2 weeks, but the full amount will be paid in this month.
Okay. Let's do it this way. How much can you pay by next Friday, you think?
Next Friday, since there's literally all of my accounts are frozen, probably nothing. But in 2 weeks, I get my bank account unfrozen. I get checks.
Okay. All right. So I'll just mark that in the file. What I'll do, sir, is I'll adjourn it out 1 week. You're entitled to that. So May 8th, 2026 at 3 p.m. That's an in-person hearing, so you got to be down here unless everything's paid in full. And then we'll see where we go from there, okay?
Yes, sir. You said May 8th, 3 p.m.
3 p.m. Yes, sir.
Yes, sir. Thank you, Your Honor.
All right. Thank you.
No problem.
Your Honor, just for clarification, does plaintiff have to appear in person too?
Ask Miss Dornbush.
Okay.
There's a little bit of an arrangement on that, all right?
Okay.
Spice Tree Apartments versus Fatma Musa.
Berta Salem on behalf of plaintiff, Your Honor.
Good morning, Your Honor.
Good morning. You'll have to uncloud your camera.
Yeah, give me 1 second here. Can you see me?
Yeah, we can see you. Okay. First of all, and I doubt plaintiff knows, did we send over this to Pallett's office?
Yes, Your Honor, we got it this morning.
Okay. There was voluminous documents filed, and I'm not clear I understand all of that. Are you still in the apartment, sir?
Yes.
Your Honor, just for the record, Fatma Musa is the defendant in this case. Is she there with you?
Father Musa and all of the occupants. So that's what we're here to talk about.
Where is she? Where is she?
Father Musa, my mom. She's sleeping.
Who are you? Who are you?
I'm her son, and I'm the occupant, and I have.
What's your name?
Abu Bakr Ibrahim.
Say again.
Abu Bakr Ibrahim. So
Is she residing in the apartment?
Petition for she doesn't reside in the apartment, she's just a leasing tenant.
Well, that's a problem because she's the one that's on it.
Yeah, I can have her come into the next court meeting in person.
Well, the problem is that she's supposed to be here today.
Your Honor, we didn't receive this notice until the 27th.
Not
So
my
there's no-
issue.
Yeah, there's no.
That's timely service, sir. So that's not the issue. The issue is that the defendant is not here.
Right.
And I don't know.
A notice to quit was put in March 5th. We didn't get that notice. Also, March's rent was paid.
But I don't know what your point is. That's not the issue right now. The issue is that you're not on the lease.
I understand, Your Honor. I've lived in this apartment for the last 3 years. I've appeared in court for eviction.
But you're not on the lease. And
right.
Then I have all of these documents which are filed, which are not signed by the defendant, it looks like. I don't know.
Yeah, they should be signed by the
that's
defendant.
her signature or not. But there is also some other huge problems that I'll adjourn it out a week. She needs to be here.
Okay.
And how do I want to say this? I'm not sure the import of all of this change of venue document. I mean, I can rule on that now. That's going to be denied because it's not a change of venue. The other thing is that other individuals, and I may indeed strike the entire documents that have been filed because you cannot change the caption to the case, which apparently somebody decided to do.
Change the caption to the case. What do you mean?
Well, I'm not here to give you legal advice. The caption of the case is changed or something, or I don't know if this is intended to be a counter complaint. I don't know what this is, but if it's a counter complaint, there's no summons attached. None of this was filed in compliance with the court rules. So all of that is going to have to be corrected. Otherwise, I'm letting you know, and you can let Fatma know that I'm going to move to strike everything because it's not in compliance with the court rules. If you need help with it, you need to get an attorney on it.
Okay.
I'll adjourn the matter out May 8th, 2026 at 3 p.m. That proceeding is an in-person proceeding. And then we'll deal with all of that. Thank you.
Am I able to say anything, Your Honor?
What?
Am I able to say anything?
What do you want to say?
Well, I've been living in this property for the last 3 years, and in February we had the unit tested for mold, and it's been
Sir,
a problem.
okay, so first of all, if you want to raise those issues, you're going to have to do it in the proper way. The documents that are filed here are not done in the proper way. So at this point, I don't think it's advisable to even hear it. You are also, well, maybe a resident in the premises, you are not the leaseholder, and I don't have the leaseholder here. So I'm giving a break by I'm not letting them take a default today, but all of these documents and everything have to be in order. I'm not requiring the plaintiffs to answer. And until I'll hear everything, but until everything's in order, I'm not going to waste my time because all of it's going to get stricken if it's not in compliance with the court rules.
Okay.
Thank you.
Thank you.
Spice Tree Apartments versus Andrew Fuller.
Fair to say that on behalf of plaintiff, Your Honor. Or here, here.
They dropped. Okay. Council, I'm going to pass this to the end. They were here and then dropped off. So, oh, maybe they're back. Hello.
Hello,
What's your name?
Andrew Fuller.
Okay, they're back. Okay. What is plaintiff's claim in the case?
Rent to retain is $5,653.02. Court costs are $169 for a total of $5,822.02.
All right. Mr. Fuller, how are you intending on getting that paid?
Your Honor, I was told that it was $4,169.50. So I was gonna pay the $4,000 today. So I'm lost about the $5,000.
Well, hold on. Is that number that you the number that you gave of the 4,000, did that include your May rent?
No, Your Honor.
Okay, that's going to be the difference.
Okay.
Okay, and that comes out about right, because if you're going to pay 4,000 a day, that's going to leave you about 1822 left. Your monthly rent's about 17, and you got court cost on that, so it's about right.
Okay.
Got it?
I got it.
Okay, so what I'm going to do is I'm going to adjourn this out to the 8th, May 8th, 2026 at 3 p.m. That's an in-person hearing if everything's not paid. And Mr. Fuller, you're going to pay 4,000 today?
Yes, Your Honor.
All right. So get that paid over to your landlord today, and then we'll come back in a week. We'll figure out where we are and see if we can get this taken care of. How's that sound?
Thank you. It sounds great. Thank you, Your Honor.
All right. Thank you. We'll see you next week.
Thanks.
Spice Tree Apartments versus Alana Grimes.
Here to Salem on behalf of plaintiff, Your Honor. Actually, this matter was dismissed. We e-faxed the dismissal to the court yesterday.
Okay. Didn't get down here, but that's okay. Case is dismissed on plaintiff's motion without prejudice. And Spice Tree versus, is it Zanhanta? Is it Juno? Or Juno? Are they here? I'm sorry. Second defendant. Brandy Noble. Brandy Noble? Juno? No. If you'd like to take a default, raise your right hand to be sworn, counsel. You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
All right, go ahead.
Thank you, Your Honor. Rent to retain is $3,982.55. Court costs are $182 for a total of $4,164.55.
All right.
Judgment to the plaintiff, that's by default. For possession, redemption amount is in the amount requested with the writ issue in 10 days.
Thank you, Your Honor.
Thank you. Spice Tree versus Brian Meeks. And there is another defendant, but there's no reason for me to do that because that doesn't happen. Good morning, Mr. Meeks. All right.
Good, sir.
What is plaintiff's claim?
Rent to retain is $3,137.20. Court costs are $182 for a total of $3,319.20.
All right. Mr. Meeks, how are we going to get this taken care of, sir?
I can get that completely caught up and paid by the 20th. By the 8th, Your Honor, I can pay I'll pay $800 or more by the 8th. And then also, Your Honor, I know this would normally be adjourned to an in-person hearing on the 8th. My older brother just passed away, and that is actually the day of his funeral. So I don't know if there's anything I can do.
That's the date of his funeral?
That is the date of his funeral. It's at 1 o'clock in Detroit.
Gotcha. All right. Over the objection of plaintiff, Mr. Meeks has been before me before. He's a straight shooter. He wouldn't be telling me that if it weren't true. He also gets himself to the point where he gets this paid. So I'm not, unless his whole personality and everything has changed, which I doubt. I'm going to adjourn this one out to the 15th, 2026 at 3 p.m. Okay. I'll adjourn it to then. Try to get the 800 in, Mr. Meeks.
Yes, sir.
All
Yes, Your
right.
Honor.
That, and my condolences to you and your family. That's always tough, right?
Yes, sir. I appreciate that. Thank you.
All right. Okay. You take care of yourself.
You as well. Thank you, sir.
Spice Tree Apartments versus Jenna Stribley.
Not sure.
Jenna Stribley, not here. Counsel, you may proceed. I should say Nathan O'Neill. Stribley, O'Neill, not here. You may proceed, Counsel.
Thank you, Your Honor. Rent to retain is $3,575.89. Court costs are $182 for a total of $3,757.89.
Judgment to the plaintiff. That's by default for possession. Redemption amount in the amount requested with a writ issue in 10 days. Valley Ranch versus Cameron Hall. And Juana Mitchell.
Beatrice Salem on behalf of plaintiff.
Good morning.
Good morning. Your name?
Cameron Hall.
Okay. All right. What's plaintiff's claim?
Rent to retain is $3,311.69. Court costs are $182 for a total of $3,493.69.
All right. And Ms. Hall, how are you intending on getting that paid?
I'm currently in school, so I've reached out to financial aid to see what can be done. I'm also on summer break, so I'm turning my part-time into a full-time job, and I just applied to another job on the side.
Okay. So you're a student.
Yes.
Okay. Where?
The University of Michigan.
Oh, that school. All right. No, I'm sorry. I'm a Maryland grad, so that's what I say. Anyway, so you're reaching, when you say that you're reaching out to financial aid, what do you mean by that?
They have I just filled out a budget paper thingy, and they'll see if they can extend the financial aid.
Gotcha. So, okay. I see what you're saying. Okay. Do you know when they may have an answer on that for you?
No, but I can go in today or on Monday and see.
Okay. All right. So here's what I'll do, young lady, is I'll adjourn this out to May 8th next week, 2026 at 3 p.m. Okay. And that's an in-person hearing. So see what you can get worked out. Do you think that there's anything that you can pay between now and next week?
Yeah, I do get paid this week, but well, not this week, next week, but I'm not sure how much I'll be able to pay. I'll pay as much as I can though.
Okay. All right. Spoken like a true student. All right. So all right. So get something paid in. I'll just mark that it's a question mark as to what you can do because you're operating off your paycheck and don't know how much. Okay. And do that, and then we'll see you next week at 3, and we'll figure out where we're going to go from here. Okay?
Okay, thank you so much.
Not a problem. What are you studying? What are you going to be when you grow up?
Sport management.
Sports management?
I want to work in sports, specifically football or basketball.
Oh, okay. So when I start my NBA career, you can help me out?
Yeah, I got you for sure.
Okay. No, that's not going to happen. I'm way too short for that. I don't have the moves, but whatever. All right, young lady, you take care.
Thank you, you too.
All right. Whitaker Oak versus Wendy Allen and David Norris.
Your Honor,
Wendy Allen. Oh, go ahead, Counsel. I'm sorry.
I apologize. We filed a dismissal with this yesterday.
That one too?
Yes.
All right. That case is dismissed on plaintiff's motion without prejudice. Whitaker Oaks versus Mark Majeski. I think he's here. And Connie Majeski. All right. Mr. Majeski, can you hear me? You'll need to unmute, sir.
All right. Am I good?
Yep, you're good. All
Okay.
right. All right. What is plaintiff's claim?
Rent to retain is $1,520.71. Court costs are $243 for a total of $1,763.71.
All right. And sir, how are you intending on getting that paid?
Well, the information I got from the office was for $1,024.73. I don't know where the extra $500 is coming from. Does that include May's rent as well?
Yes, it does.
Yes.
Okay. I made an arrangement to meet the property manager after my work hours last night. I told her I'd be in front of the office to give her the $1,024.73 at 7:15, and she never showed up. So I have the money orders for everything up until May's rent.
Okay, so you have 1,024?
1,025.
Okay. 1,025. And is the office open at particular times?
They're open now. They weren't
Okay.
open at that point in time, but I had called yesterday afternoon about 2:30 and told Danielle what was going on, that I'm a car salesman, that I had a late delivery and that I could be there by 7:15, and she agreed to meet me and then never showed up.
Okay, that's fine. I'm not going to so much worry about that. You think you can get that 1,025 down to them today?
Absolutely. I got to go to work, so I
Okay.
got to drive right by there.
Okay, fantastic. Get that paid today. I will then adjourn this out 1 week to May 8th, 2026 at 3 p.m. That's an in-person hearing. And then we'll see where we are and see if we can get this resolved. How's that sound?
I plan on having the balance paid by then anyways, because it's rent time.
Okay. So if you pay it all off, then what's going to end up happening is you won't need to show. Just make sure everything's paid. You won't
Okay.
need to show, and they'll dismiss the case.
All right.
Your
Okay.
Honor, if I may, just for the record, the total amount that I provided today does have May rent, but it does not have sewer and water charges. There was some issues with getting those numbers before today's hearing, so I just would like to clarify that for the record.
Okay. So there might be some additional sewer
Sewer
charges and other. Okay.
Will that be
Well, we'll sort
included
it
in
out.
what?
Go ahead, sir.
Will that be included in the balance, or can I pay that after I pay the balance? Because I don't want to get caught up, and I don't want to. It's very hard for me that this is happening. So,
Okay, Mr. Modest, listen. Let's just work it this way. Get the 1,025 paid. Then you
Yep.
said you're going to pay your rent at some point, right?
right before then.
So pay your rent. If for whatever reason those sewer charges aren't there yet or whatever, and there's some additional amount on there, I'm not going to let anything happen to you because you're going to have the bulk of this paid off. So don't.
Okay.
I get that it's hard. I'm not going to let anything happen. You'll be good.
Okay. Thanks, Judge.
All right. You take care.
You as well. Have a great weekend.
You just say, what kind of cars do you sell?
Fords.
I like him. I'm a Ford guy, so if you said Chevy, I was gonna kick you out of the Zoom room. Anyway.
Okay. All right. Let me go sell some Fords.
What'd you say?
Let me go sell some Fords.
All right, sir. You take
Have a great
care.
day.
Have a good Whitaker Oaks versus Hunter McNiff. And
I do see
Ash
the
McKenna. Yeah. Ashley. All right. I don't know why the syllables aren't happening. Ashley, what's your name?
Ashley McKinka.
I did say it right. See?
I think so. I didn't hear you right away.
Okay, no, it's like everybody around me was yelling at me saying I didn't say it right, but I thought it. Anyway, okay, they weren't, but whatever. All right, what's the claim in this case, counsel?
rent to retain is $1,698.20. Court costs are $243 for a total of $1,941.20.
All right. And ma'am, how are you guys gonna get that paid?
So I gave them, I did give them money orders in 1,700 last night. I delivery drive, so I can't give it for sure when I can give the rest. But I should be able to get it to them by the 5th. The rest of, I think the 5th is like Monday, I believe. Oh, the 4th is Monday. So over the weekend, I should be able to give them the rest to catch up April. I am also waiting for the deposit of my state taxes just so I can pay ahead May as well.
This number, hold on.
Go ahead.
This number, counsel, includes May.
Correct.
That
And
one
we
does-
do
okay.
have that $1,700 payment reflected on our ledger.
Right. What did you say, counsel? I'm sorry.
The $1,700 payment made yesterday is reflected on our ledger.
Oh, okay. So that's already paid. That's already on there. And she still owes the 1941.
Correct.
So
Okay.
May rent by guaranteed will be paid in full by May 11th. I did tell them May 10th yesterday by accident, but I didn't realize that was a Sunday.
Okay, so here's what I'm going to do. May 8th, I'm going to adjourn this out to May 8th, 2026 at 3 p.m. That's an in-person hearing. What I'm going to suggest you do is contact the attorney's office or contact your management, see if you guys can work out how you're going to get all of this paid up.
Okay.
Okay, and whether it can be a consent judgment or a conditional order dismissal just to try to get this resolved, all right?
Okay. Thank you very much.
All right, thank you. Have a great weekend.
You too. Bye-bye.
Whitaker Oak versus David Petrowski and Vicky Pitt.
Hello.
Hello, sir. All right, Mr. Petrowski. All right, so what is plaintiff's claim?
Rent to retain is $3,172.21. Court costs are $243 for a total of $3,415.21.
All right. And sir, how were you intending on getting that paid?
I can pay $1,500 today, and then I can have the rest by the 27th.
All right. So $1,500 you can put in today?
Yeah.
Okay. So get that paid. I'll adjourn this out 1 week to May 8th, 2026 at 3 p.m. That's an in-person hearing. In the interim, contact the plaintiff's attorney's office. You'll see it on your paperwork. All right. And see if you can work out either consent judgment or conditional dismissal. Since you have in your mind how you can get this paid before the end of the month. Okay.
Okay.
All right. Thank you, sir.
Thank you, sir. Have a good weekend.
You too. Is that again? What's this? Oh, okay. All right, counsel, I think that's it for you.
Yes, it is. Have a
All
good
right.
rest of the day. Thank you.
And I'm not going to say you did a better job than Dornbush. All right.
Have a good one.
We'll make that our little secret. All right. Take care.
Bye.
Bye-bye. Okay. Ridgewood Apartments versus Anthony James. Ridgewood Apartments, Anthony James, indicate neither party appeared, case dismissed. All right. And that's it for us for today. I have a 1 at 10 a.m. All right. All right. And that's it for the 8:30. Thank you, folks. Those I won't see, have a great weekend. Sports and racing.
Good morning, Your Honor. Olivia Camaro appearing on behalf of Plaintiff Pierce Lake Village Association.
Good morning, Your Honor. Travis Gagnon appearing on behalf of defendants James E. Heaton Trust and Tenant.
Your Honor, can we address a housekeeping matter prior to getting into the motion, please?
What is the housekeeping matter?
So at the February 20 hearing that we were at, it was relayed to the court that defense counsel represents all defendants. And I wanted to confirm that defense counsel does in fact defend all defendants. He advised
the defendant, Mr. Haythorne, right?
Yes, sir.
Representing himself, we have standby counsel, Mr. Helbling, and we have Mr. View from the prosecutor's office. We are here today for a plea hearing. It's my understanding that since the last time we were here, there have been some plea negotiations. I understand that there is an offer from the state to reduce the charge to a F3, which would be an agreed 24-month sentence with no judicial release. Is that accurately stated, Mr. View?
I mean, in a sense, yes. I mean, the offer was made to me from the defense and was accepted by the state. That's why we scheduled for a plea today. But yes, if Mr. Haythorne is prepared to go forward today, we are prepared to resolve the case today.
So, Mr. Haythorne, it's my understanding that even though you're representing yourself because of the logistical problems and you communicating directly with Mr. View, that you sought the assistance of Mr. Helbling to try to communicate a resolution to the case. Is that right?
Yes, sir.
So where are we at on this?
Your Honor, may I speak?
Sure.
For the record.
Is that okay with you, Mr. Haythorne?
Yes, sir. Mr. Haythorne gave me the ability to negotiate the F3 as we discussed. I just need to put this on the record. The offer was for a 2-year deal on the F3 of the attempt. I received word back via email from Mr. View that that was accepted. Nothing in either of our emails discussed judicial release. I've spoken to Mr. View, and he'll correct me if I'm wrong on this. He took that to mean no judicial release. I did not mean that, but it's in the plea form. So it's there. But that was not part of my negotiation or understanding, just for the record.
Okay, so something got left out. Mr. View assumed that if he is going to reduce the charge to an F3 and agree to 24 months, that it was going to be with no judicial release. Maybe that wasn't an assumption that was shared on your part, but it is my understanding as we sit here today, Mr. View, the state is only willing to reduce it for a 24-month with no judicial release, right?
That's correct, Judge. Yes.
Is that acceptable to you, Mr. Haythorne, or not?
Just so the record is clear, on April the 8th, I responded back to Mr. Helbling. John, I appreciate your offer and your efforts on Mr. Haythorne's behalf. I have discussed your client's offer with OSHP, ODRC staff, and within my office. I just want to confirm that this is an agreed sentence with no judicial release and that it will be served consecutive to Mr. Haythorne's current sentence. Your email does not reference a consecutive sentence. I will not accept concurrent sentences. Please confirm that your client's offer is a consecutive 24-month sentence. Mr. Helbling responded to me then on April the 8th, indicating it is for a consecutive sentence of 24 months. So I did clarify to him in my email that it was for no judicial release.
All right. A lot of people are telling me stuff that I don't care about. All I care about is where we are today. And as we sit here today, F3, 24 months, consecutive to the time that he's doing, no judicial release. Is that right, Mr. View?
That is correct, Judge.
Mr. Haythorne, do you understand the terms of that?
Yes, sir.
Is that what you want to do or not?
Yes, sir.
Okay, there's a plea form in front of you. Normally, I have the attorney review it with you. I'm willing to have Mr. Helbling sit with you since there's no jury here, Mr. Helbling can sit with you if you're okay, review that plea form with you. Is that okay? Is that what you want, or would you rather just read it by yourself?
Is it all right? He reviewed with me, sir.
Okay, let's go ahead and take a break. Mr. Helbling, you can review the plea form with him. And if this is the way we're going, then let me know when we're ready and we'll be back out. I feel like
Travis, what was that, the date on that email you read from?
I'll print it out for you, John.
Thanks.
Court that he was planning on filing a motion to dismiss the Ellen Trust on the basis that she had no alleged interest. And that motion has not come through, and their captions seem to state that they only represent the trust, the Heaton Trust, and the tenant. So if that's the case, I'm going to need to default the Ellen Trust, but I just want to confirm.
We filed an appearance on behalf of the James Heaton Trust and tenant only. It is still our position that the other trust has no ownership interest in the unit that's in question. And again, it's not that I won't file a motion. Our motion that is teed up today is to adjourn the trial, which would seemingly bump the motion hearing or motion filing deadlines as well. That will likely be a part of the motion that's filed at that time.
I don't know if that's a housekeeping matter or not. I mean, if you believe that they're not representing them and you want to file a motion for a default, I think you need to file your motion.
Understood, Your Honor.
All right, Mr. Gunyu, it is your motion, sir.
It is. Thank you, Your Honor. Hopefully it's a simple motion here. On April 10th, we had a hearing in front of this court, and we had set the date for a non-jury trial for May 5th. At that time, only counsel was required to be present at the hearing, and counsel checked their schedules, and it was clear of any conflict for the May 5th deadline, or for the May 5th trial date. Within that following week, I was able to meet with my clients, explain to them what the next steps were, and that there was a trial that had been set. It was only at that time I was informed that there had been a long-standing travel that had been planned by my clients, who are not only just named defendants here, they are representatives of the trust that owns the unit, but also key witnesses in the trial, that they would be out of the country, and I think it was until May 18th. Given that it was a 3-week lead time or a 2-week lead time at that point, they were not able to cancel their travel. And I, that same day, reached out to chambers and counsel to try to see if we could set another trial date, whatever the soonest available trial date was, following their return to the country, May 18th. We were given June 2nd as a potential date and told that we should stipulate. I communicated with counsel via email and phone calls several times. I wrote them that day. I wrote them the following week. A couple of times in follow-up. I left 2 voicemails and I never heard back from counsel. So without hearing anything further, I filed this motion to adjourn the trial date so that I could have my key witnesses as a matter of due process here, so that we have are able to present our defense. In the response, which is the only response that I've heard back, whether email or formally or informally, they cite MCL 600 got 5735, two different sections. These are for summonses.
I know.
So
I'm well aware of that. And I'll get to it when I hear their response, because I think the response is frivolous in a lot of ways.
yeah, and I will just point out, Your Honor, my last thing, we've already extended deadlines in this case.
That are on page 2 of the plea form. He'd like for the court to clarify if he's agreeing to 2 years, why that language has to be in there.
So you're going to serve a 2-year prison sentence consecutive to the time that you're doing. Then you're subject to, for F3, it's an optional period of post-release control of 2 years. Is that right?
That's correct. Up to 2 years.
So then after you're done serving your sentence, the adult parole authority can, but they don't have to, supervise you for a period of up to 2 years after you're released from prison. They will put you on post-release control. If you violate the terms of that supervision, then they can return you to prison for up to 1/2 of my original sentence, meaning a year, or up to the time that you have left on post-release control if you violate post-release control by committing a new felony. If that's the case, then you can be returned to prison for up to the maximum or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period. So you would do your 24 months, and then you would be subject to post-release control at the discretion of the Ohio Department of Rehabilitation Corrections.
He's serving a sentence for aggravated robbery. I mean, he'll be placed on mandatory PRC.
Yeah, I mean, you're already going to be on PRC anyway because of your underlying offense, but if something happens that your other offense got thrown out and this was the only offense that you were serving time on, then you would be subject to an optional period of post-release control of up to 2 years. Do you understand that? All right. You ready to go back to the form? You want us off the record?
Back to the form. Sorry.
All right.
Before, at plaintiff's insistence, we had our hearing in March that was scheduled. Plaintiff reached out and asked for a stipulation to move that date, which again is far beyond 10 days from the filing of the complaint. We did stipulate to that and moved it to the April 10th date to cooperate with counsel. Now we're being told that it's not a matter of discretion and that there's no power to move beyond based on this good cause. So that is all I have, Your Honor. Our request is that we move the trial date to June 2nd, or if counsel or plaintiffs are unavailable on June 2nd, we're happy to find another date that works where everyone is present.
Response.
Your Honor, MCL 600.5735 sets the dates that the summary proceeding must occur after the issuance of the summons.
How long have you been doing summary proceedings? Because what's the date of that statute?
It's been effective since, it's at least amended since 2004.
Correct. And in 2020, particularly Supreme Court Administrative Order 2020-17 changed that, correct?
I would need to verify, Your Honor.
Yeah, you should have looked at that before you filed this response. Go ahead.
Your Honor, we largely rely on our response to the defendant's motion.
Yeah, but I got questions regarding the response, because what you put in the response, it seems to me to be frivolous regarding an argument for a motion to adjourn the trial date. You're indicating that the court doesn't have discretion, that there's got to be a hearing, without any analysis of the original statute that provides for service and a hearing date from within the 3 to 10 day range. But that's when trials weren't held in the manner that they're held right now. And so I don't think that you necessarily, if you want to try to explain what all of this that's in here, then you might want to do so, because I consider many of the arguments that you make here absolutely frivolous and not taking into account the statutory and court rule changes that have occurred regarding summary proceedings.
Respectfully, Your Honor, again, our position is that the statute places a limitation on the adjournments and
Give me the court rule, by the way. Court rules will supersede statutes on procedural matters. That has always been the rule. So give me the court rule that does not give this court discretion to adjourn this trial.
I mean, Your Honor, under MCR 2.001, the court rule yields to the statute.
On procedural matters?
The language in 2.001 specifically states that the rules in this chapter govern procedure in all civil proceedings in all courts established by the Constitution and laws of the state of Michigan, except where the limited jurisdiction of a court makes a rule inherently applicable or where a rule applicable to a specific court or a specific type of proceeding provides a different procedure. Our interpretation of that specific type of proceeding provides a different procedure read in conjunction with the Summary Proceedings Act, which provides.
Be kidding me. Read the first sentence again.
The rules in this chapter govern proceedings in all civil proceedings in all courts established by the Constitution and laws of the state of Michigan.
That's it. The rules govern the procedure. So why didn't you, and also the rules do require where somebody reaches out to the opposing side that there is to be some type of either concurrence or not concurrence in a motion that's filed or a request. So why didn't your office respond to defense counsel's request? I'm not saying what the response has to be, but the very fact you didn't respond.
Yes, Your Honor. So while Mr. Ganyu, and I apologize if I misstated that, when he called me, I was in a client meeting, and then the email had already come in that he was moving to adjourn it. And so I didn't have the time to give him a call back and explicitly state that we weren't going to proceed with concurring, but my understanding or my position was a non-response is the same as not.
No, it is not. That cannot be your response. You're going to tell me when opposing counsel reaches out to you, even if you don't agree, that you have no obligation to respond? Is that what you're telling this court?
No, Your Honor. I was intending on originally giving him a call back, but the motion had already came through. I was in a client meeting when he called me.
Your Honor,
You're saying there wasn't a time between his original contact with you and the filing of the motion that you had no way of reaching back out via email otherwise to him? Is that what you're representing to this court? Be careful on your answer.
No, Your Honor.
That's not what you're saying to this court, because I really hope you're not.
No, Your Honor.
You have previously adjourned dates in this case, correct?
Correct, Your Honor.
And you sought the concurrence of defense counsel to adjourn those dates, correct?
Correct, Your Honor.
Then explain to me why you would not show the same courtesy.
Your Honor, we have shown the same courtesy. They also asked for 2 specific adjournments. And in this scenario, the client wasn't willing to give another stipulation to adjourn. We recently received body cam footage of recent calls out to the unit, and
Did that get filed with your response?
no, Your Honor, we actually received it via FOIA request yesterday. And so I was able to watch the body cam footage of what the noises sound like, which really puts into perspective the disturbance that this has caused the neighboring co-owners, which helped me understand why the client was not willing to allow me to stipulate to adjourn.
When did the supposed noises and everything occur?
The body cam footage that I received yesterday, I can give you the specific dates if you could give me one moment, Your Honor.
Yes, please.
So one of the body cam videos is dated 3/10/2026.
3/10?
Yes, March 10th. The other 2 of them are dated 4/13, and then there's one on 4/15, excuse me.
Daniel, you know anything about those?
I don't. I am happy to look into them, but I have not seen any of the body cam footage.
I just received them yesterday, Your Honor.
Back to your motion. Did you even, I mean, I'm going to ignore your section 3 regarding the court rules and general discretion not overriding Summary Proceedings Act, because I quite frankly don't think you know what you're talking about, because you haven't gone and looked at 2017, which changed everything. You also have not gone into looking at the way in which summary proceedings are now handled, and that they were specifically overridden by the Supreme Court regarding certain procedural issues, and then incorporated within the court rules that you say don't override particular statutes. And that's just wrong. I can't, it's just blatantly. And obviously, doesn't make any sense to me. If there are issues, certainly, that regarding the defendant's conduct that you become aware of between the time of a trial date and the time of the setting of that trial date, much like every time, and obviously you don't know how this court works. If you filed a request for an emergency hearing on it, this court would do everything to accommodate that. So if there are issues that are involved between the time of the trial date and that, court will address it. But in that regard, we don't practice law here in Washtenaw County by sandbagging. So if you've got evidence of something that is going on, you present that to opposing counsel, see if the resolution can be worked out. If it can't be worked out, you contact my office, you file a motion, much like what happened here. This court will accommodate it within its schedule and get you in to address whatever the issue is. We don't practice this way here, certainly not in this court. I am going to, for the time being, ignore this very poorly researched response. Quite frankly, I think what's in there and it's sanctionable. And I'm going to decline at this time to do that. I will take my request, because it's not going to be defense counsel's request. The request for sanction, I'm going to take that under advisement. So you need to understand, counsel, that doesn't mean that I will not, but I'm not going to at this point. I will also not award to defense counsel attorney fees and costs in this case, but I am going to adjourn the trial date. And I'm going to make it very clear, counsel, so that if you want a written order to that effect, then I'll give you a written order. I don't think it requires a written order. That if there is a circumstance where I find that opposing counsel is not responding, then I am going to sanction, and I'm going to sanction hard. That is not how one practices law. Having considered the motion and the response for whatever the response is, non-jury trial in this matter will be adjourned. I will adjourn the matter to June 2nd, 2026, 9 a.m.
Thank you.
That is all. Mr. Gunn, you prepare an order to that effect, please. Thank you.
Sir. Thank you, Your Honor.
Thank you, Your Honor.
Nine. This is an ordinance case. Oh, you accept that, Ms. Wilson?
Huh?
Yeah, you were appointed 139.
Yeah.
I guess Whiskey would do that. Let's pick a date. Well, I lose the 20th is a jury trial date. 13th is too close. 27th, I'm going to be trying a circuit court case. And Monday, the 25th, I hate to bump everything out to June. Paul, are you available on Wednesday, June 3rd at 11?
I don't have my schedule with me, so I guess I can check on that right now real quick, but I'll assume that that's okay. June 3rd at 11. What kind of a day is that?
That's a Wednesday.
Okay.
Does that work for you?
Yeah, that's fine.
You owe us some money. You've got a no ops, or no insurance and a no ops. You've got $339 worth of unpaid fines and costs.
Yeah, I was gonna pay it on the 5th is when I get paid.
All right, well, you don't have to pay it all at once, but it would be very
yeah,
helpful
I was
if
gonna
you
make
pay it
payments.
before I see you in June. All right, I'm gonna have the officer take you out. This is yours.
We have Mr. View from the prosecutor's office. We are here today for a pretrial. It's my understanding that Mr. Meester is going to waive his right to have this case heard by a jury, and we're going to set it for a bench trial. Is that accurately stated?
That is accurate, Your Honor.
So, Mr. Meester, in a trial in the state of Ohio, we divide the responsibility between the jury and the judge. The judge decides what the law is, and the jury decides what the facts are. So, were you to try this case to a jury, I would instruct them on the law, and all 12 of them would have to be convinced beyond a reasonable doubt that you're guilty of this to return a verdict of guilty. They also have to all agree that you're not guilty. If they can't agree, then that's what we call a hung jury. There would be a mistrial in that particular trial. If you waive your right to a jury, I would decide both what the law is and what the facts are. I'm not going to find you guilty of this unless I'm convinced beyond a reasonable doubt that you did this. Do you understand all of that?
Yes, Your Honor.
Did you have a chance to talk about this with your lawyer?
Yes, Your Honor.
Are you satisfied with the representation that you've received so far?
Yes, Your Honor.
I have a one-page document entitled jury waiver. It's got a signature at the bottom. Is that your signature?
Yes.
Is this what you want to do?
Yes.
All right. I am going to accept the jury waiver. I think it's been made in a knowing, voluntary, and intelligent fashion, only after you have been fully advised of your rights in that regard. We'll get the case set for a, what is it, one-day trial, do we think?
I'm sure it's a one-day trial. Yeah.
All right, we'll set it for a one-day trial to the bench. Mr. Bly, Ms. Ida will reach out to you via email to get a date. And I have a report from pretrial services that everything is going fine.
Okay, thank you, Your Honor.
All right. The case of the state of Ohio versus Dominic, am I pronouncing that right? Seminator?
Yes, Your Honor. Seminatori.
Seminatori, case number 25 CR 42892. Present before the court is Mr. Seminatori, represented by Mr. Crossing. We met some of you from the prosecutor's office, Officer Martinez from probation. We're here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor.
Yes, Judge.
Any reason not to go forward with sentence today?
No, Your Honor.
No, Your Honor.
All right. We didn't have a jail time credit figure, did we? Or was it?
3 days.
3 days.
3 days of jail. Okay. All right. Prior to today, the court did have the opportunity to review the victim impact statement. It was a two-page letter by Alicia, I'm going to butcher that, Chiberiak, who is designated as a victim representative. Mr. View, anything additional from the state or on behalf of the victim?
No, Your Honor. Ms. Chiberiak is present with the victim's advocate, and she had no additional presentation for the court at sentencing.
Officer Martinez, anything from probation?
Nothing further than what was discussed in chambers, sir.
Counsel, what do I need to know about this, if anything?
Yes, Your Honor. He has no prior offenses. He's an RS score of 1. The only reason he had any score on that at all was because he's currently unemployed, but he is volunteering with the JROTC. That's certainly the lowest score that I've seen. He's en route to join the Navy. This is going to have an impact on that. And there are collateral consequences for bad decisions, and he understands that. So I'm not indicating to the court that it would be unfair, but I want the court to be aware of his background and how it's going to impact him. He will probably have difficulty being able to join the Navy while he's serving any type of community control, if the court would allow that. So it's going to have that impact on him. We're hopeful. He did speak with the recruiters. We're hopeful that these convictions aren't going to prevent him from joining. So he's still going to be able to move forward. The plea deal here is giving him that chance or that opportunity that he otherwise wouldn't have had. So we certainly appreciate that. He has already taken the ASVAB test, so this is not a hopeful someday. This is the route he was on prior to this occurring. We submitted letters to the court from his JROTC commanders. None of them have ever had issues with him in terms of him acting out. Now, this is something where he should have, when this occurred, should have just escalated the matter through the program that he was in, not try to handle it himself. He's an 18-year-old young man. He acted immaturely, incorrectly, and that's why he's in front of you. So he understands that, but I don't think it's indicative of someone who's going to commit future offenses. And also these convictions by their very nature will be on his record for life. And it's something that's he's going to have to deal with, but he understands this because of his own actions. We'd ask the court to consider all of that and take it into consideration. Thank you, Your Honor.
So, Senator, you get the last word in this. What do you want to tell me?
I really deeply regret this, Your Honor, and I'm really sorry for what I've done, and I wish to never make this mistake ever again.
All right, what I'm going to do, Mr. Senator, I'm going to put you into my community control program on basic probation for a period of 1 year. I'm going to impose upon you the standard rules of community control. It's going to be a special term of your probation that you enter into and successfully complete an anger management program. I want you to complete 40 hours of community service. You're not to have any contact with the victim in the case or any of the victim's immediate family. And you are not permitted to get a job where you are working with children. It's also going to be a term of your probation that you are to obtain your high school degree. It seems like that's already on track to happen, so that's not going to be an issue. I'm not going to impose a fine. I am going to impose the costs upon you. And I'm going to give you credit for the 3 days in jail that you've already done. I don't see a need at this point to send you back to jail, Mr. Seminatori, because I think I have. Mr. Seminatori, because I think I have a sense that this is something. Good luck to you, Mr. Seminatori.
Thank you, Judge.
Why don't we have everybody on the left side of the courtroom? Let's just hang out for a second and wait. All our folks on the right side, we can go ahead and clear out because the hearing is over. I'll give you more information about when to come back for the screening and sentencing.
Okay. Oh, let me write this down. All right, I wrote that down too. Well, I need to make sure I have your phone number though.
Patrick Jones.
He's in custody.
We're gonna have to wait for him. I gotta get Casey out of here by 11. Let's make a record on our no-shows. Curtis Williams, file
Okay.
number 26348.
This is the Arthur Jones.
He has $804 of unpaid fine and costs. He's failed to appear. Do you have any contact with him?
With who?
Curtis Williams.
No.
I'm gonna do a $1,000 cash or surety warrant with a 48-hour hold. And that's not my idea. The Criminal Justice Reform Act says we're supposed to put a 24-hour hold, which makes a huge pain in the neck. When people do show up, we have to drop everything and deal with them. Stephen Higgins, file number 25. Five 1670 251671 251672. Mr. Higgins has $765 worth of other unpaid tickets. I'm not very happy that he isn't here. I think I talked to him at a previous bench warrant arraignment. I talked to him in October. And I talked to him in March. I let him out of jail in March. All right, 250 cash security per file. 48-hour hold. Mr. Higgins is local. He lives in White Pigeon. I don't know why he isn't here, or why he never bothered to contact his lawyer. If I do have him arrested on a bench warrant, I'm gonna leave him sit until I can get you available, Mr. Gibson. So, Mr. Higgins, you need to get in here. Mr. Jones is complicated and he's in custody. So let's set him aside for a minute and take some of the people that are here live. Christopher Waycaster.
And Your Honor, for expediency purposes, Craig Klopfenstein and Dylan Southland are both admitting responsibility to civil infraction tickets. Could they take their paperwork to the counter?
Yeah, let's do this, then we'll do them. Mr. Klopfenstein has a hard time standing and sitting for a long time. We'll get him out of here next. Sun's coming out. That's something, kind of. Good morning, sir. Are you Christopher Eric Waycaster?
Yes, sir. Good morning.
You're charged with fraudulent use of malicious use of a telecommunication device and molesting or disturbing workers by threats, intimidation, otherwise intent to interfere with Amy Smith and apply unpeaceable pursuit of her occupation. That's a relatively new statute. is a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. They would dismiss the malicious use of a telephone device as a result of that plea. Are you going to plead to that lesser charge? No, this is the last pretrial.
Yes, Your Honor. My first contact with Mr. Wakecaster was this morning. We have discussed this, and given the nature of the charges, the prosecutor has offered to leave this recommendation open, this offer open until the time of the last pretrial to allow Mr. Wakecaster to ask and have answered any and all questions related to the charge, so he has a full understanding before a plea is entered.
Mr. Wakecaster, have you got a place to live?
Yes.
Or why didn't you contact your lawyer until this morning?
I made 2 calls and they said she was not employed at the.
He called my former office, Velakis and Velakis. I gave him another copy of his petition for court-appointed attorney, circled my phone number so he can make contact with me.
All right.
At that point, I figured.
Did we do that?
No, it was correct on his paperwork.
All right. Maybe just looked her up on the internet.
Maybe that could have been why.
She's kind of famous, but she's not with that firm anymore. She was stolen by another firm. All right, I understand. So we will set a last pretrial to be set on a Thursday afternoon, hopefully. Are you living in Elkhart?
Mishawaka at the moment.
All right, stay in contact with your lawyer. We'll set a last pretrial on a Thursday.
What's the date?
I don't know the date right now.
You'll have to get the date for me, so stay in contact.
Mr. Wakecaster, you've also got $135 with unpaid fines, hunting from a motor vehicle, so $135, and you got a disobey stop sign ticket that's percolating around out there somewhere. So I would suggest you stop out at the counter before you go.
I can't make a payment.
Well, just check in and I'll tell you what the deal is.
Okay. Is that it?
Yes.
Thank you. Be in contact.
Thank you.
Craig Kloppenstein. Here it is. All right, good morning, sir. You're Craig Kloppenstein?
Yes, sir.
Again, I know you, but I have to identify you for the record. You got charged with retail fraud in file number 26277SM. That's a misdemeanor. The way they charged it is up to a year in jail and a fine of up to $1,000. Prosecutors agreed to dismiss that for a plea to the civil infraction of retail fraud. Three Rivers and Sturgis have a civil infraction. Civil infraction is not a crime. It's a civil penalty. The fine's $100. It's like running a stop sign or speeding or something. You're going to admit to the civil infraction of taking some property from Nards on that day?
Yes, Your Honor.
All right.
And I believe there's $16 in restitution as well.
All right. All right, fine and cost is $100 plus 16 restitution. Can you pay that today or you need time?
I need time, Your Honor.
All right, we'll make that due by 1/16/5/30/26. This is not a crime, it's a civil infraction. You can't go to jail for a civil infraction. I want you to pay the fine or at least make a dent on it and we'll discuss it further. But otherwise, this case is dismissed.
Thank you, Your Honor.
All right, I'll see you next or later this month. Dylan Southland. Are you Dylan Southland?
Yes, I am, sir.
You're also charged with retail fraud, third degree in the city of Three Rivers, alleged to have June 16th. Got to tell Mr. Kloppenstein was barred from the NARS. They probably already told him that. They made the same offer to you, sir, to dismiss the misdemeanor charge for an admission to the civil infraction of retail fraud. They're asking for $148 for the restitution. Let's take a look at this. According to the complaint, you were at the Three Rivers Walmart store and you took some property worth less than $200. Well, they're asking $148 of restitution. To understand that when you admit to a civil infraction, you don't plead guilty or not guilty, you simply admit, you understand?
Yes.
What do you mean? You have the price that's percolating out there somewhere. I think all of them have. I haven't seen this file yet. But there's some notes for you. Well, I just trip over it. All right. I guess I could pull this drawer out and stick it in there. Maybe. All right. So do you acknowledge that you took some property from the Walmart store in June of 2025?
Yes, sir.
All right. Do you still live in Springfield,
Yes.
which is in Calhoun County?
Yes.
Are you employed?
No, not at the moment.
All right. Fine and cost is $100 plus $148 restitution. So $248. You're barred from Walmart 1 year. Scooter. Someone was with you, a female. Did she get charged also or just you?
I do not know, Your Honor.
I'm asking you, do you know?
No.
Just you?
Yes.
All right, well, they identified your car and you from the video. You had a warrant for embezzlement from another jurisdiction. What's the status of that?
It's just for finding costs right now.
All right, what county was that from?
I think Calhoun, I'm pretty sure.
All right, well, this sounds a little wobbly, but I'll accept your plea. You owe $248 by May 30th. Did you get picked up on this case and go to jail?
Yes.
How long were you in jail?
I was there from Friday to Monday.
Well, I can't do jail on a civil infraction. If it was a misdemeanor, I'd have given you 3 days jail credit, 3 days, but you can't go to jail for a civil infraction.
Appreciate it.
All right, you're good to go, sir.
Thank you.
Alexandra Snyder. Good morning, Ms. Snyder.
Good morning.
This is file, gosh, 26508 OT. You're charged with driving suspended, disorderly person, and disobeying a traffic signal. You've also got $1,296 of unpaid fine cost. Prosecutor has offered plea offer. I'm not clear. She's unwilling to accept it at this time.
Your Honor, she has a couple of other things going. She has another misdemeanor operating while intoxicated with me. She also has a felony operating while intoxicated, high BAC, and resisting and obstructing a police officer with Attorney Truckee. We're hoping to wrap everything up together at this time.
I was just a little confused on which case I was here for.
Well, Ms. Snyder, these are among the smaller things that you're dealing with. You are really struggling. I first met you when you were about 17. You got a new baby, you got a lot going on. I used to see you at Subway. We'll set this for a last pretrial on Thursday, and your two lawyers are gonna see if they can work everything out.
Thank you.
All right, you stay in contact with your lawyer. As far as I know, you always show up for court. But don't get in any more trouble.
I don't plan on it, Your Honor.
All right, there's no alcohol conditions on your other stuff. No driving, no alcohol.
I don't plan on driving.
All right, good. You're
Thank you so much. Thank you.
Oh, we're plugging away here. Ashley Armour.
And she's gonna be a plea, Your Honor. I have two other last pre-trials, if those
We'll
are.
go ahead and do this.
Okay.
What did I do with my, there it is. Good morning, Ms. Armour.
Good morning.
This is file number 26437 SD. Can you read this?
26437 SD
You can.
and 26-706.
So it's just me as microscopic.
It's very microscopic. I'm surprised that.
Okay, messing with me. Ms. Armour, you're charged with operating while intoxicated. You've been here all morning. As you see, we've had several of these today. They've made the same offer in your case they have in some others. They've offered to dismiss the driving suspended for a charge to impaired driving. Understand?
Yes.
Impaired is a lesser charge. It's punishable by up to 93 days in jail and a fine of up to $300. It carries 4 points and allows you to keep a restricted driver's license to drive back and forth to work. You understand?
Yes.
Now, do you understand that by pleading this charge, you'll be giving up these rights on the advice of rights? There will not be a trial.
Yes, sir.
Let's take a look at your case. You got a ticket at 2:30 in the morning on March 6th, right here in Centerville. You have your lights off, which will get you pulled over every time. They're gonna dismiss the, yeah, proper lights. That'll save you $105. Better than poking the eye. Where were you going, Miss Armour?
To show
Where are you coming from?
my house.
What were you drinking?
Mixed drinks, Captain Morgan.
What were you getting to show?
Snacks.
All right, sometimes it's cigarettes. People need to smoke in the late night and they drive where they shouldn't. What was the blood alcohol?
It was 0.136 grams of alcohol per 100 milliliters of blood, based on the MSP laboratory report, which has been shared with Ms. Armour.
You heard what I said earlier. When you have one or two drinks, you're thinking, I probably shouldn't drive. When you get to about 1-3, it's like, yeah, I can drive. I can sneak down to the gas station and back. And then you didn't even turn on your lights. Of course, you didn't go very far. You live right on James Street.
Yeah,
Could have walked.
I know.
That probably was, well, that was the day of the tornado. March 6th was Friday. The day the tornado hit. Centerville didn't get hit too bad. All right, Miss Armour, what are you doing these days? Are you working somewhere?
Yeah, I work at the Country Table in White Pigeon.
Okay, I haven't been there in a while, but I like it. All right, let's find a date that works for your lawyer. We usually use Wednesdays for the. Are you available June 3rd, Casey?
I apologize, Your Honor. Yes, I am.
All right, Miss Armour, I'll give you this. Set for Sundays.
Perfect. Perfect.
And the bailiff will take you out and I'll get that. The no lights is dismissed, which is gonna save you $105.
Yep, you're good. Thank you.
All right, let's talk to Jason Kessler. The guy's out cold, but he wasn't causing any disturbance, so I let him sleep. It's pretty boring around here. You're Jason Eugene Kessler?
Yes, Your Honor.
You got charged with operating while intoxicated near your home on February 11th. The blood alcohol was 0.299. The prosecutor, I guess, has agreed not to charge high BAC. But at this point, you wish to have the matter set for a final pretrial, is that correct?
Yes, Your Honor. In my conversations with the city attorney, they would consider a reduction if we have some mitigation information. They would also leave the OWI first offer open until then.
We first thought you didn't show up.
And Your Honor, I was calling people in. I didn't see him wave his hand. He was here. He was one of the first
It
ones
was so
here.
busy out in the hallway that apparently you were here. All right, we're gonna set this for a Thursday afternoon. Let me see if you owe anything. I don't see that you do.
You'll just have to keep it because I'll get your court date.
We'll reset it, get some more information, discuss what's going on. 0.29 on is a very high blood alcohol level. We're kind of getting desensitized to them. Anyway, we'll set a final pretrial on Tuesday afternoon. That works with, excuse me, a Thursday afternoon that works for your lawyer. You're good to go, sir.
Okay. Just stay in contact with me.
Okay, thank you. Jared Tuttle.
Morning, Your Honor.
Good morning, sir. You're Jared Tuttle?
Yep.
Again, thank you for your patience. This is part of your legal education. You get to sit here and watch what everybody else has going on.
Yeah.
There is some value in that, but this is a public proceeding and everybody's welcome to be here. But it's a long morning on the first Friday of the month.
I'd rather watch it on YouTube.
You can sit on your couch. At any rate, you're charged with domestic assault. It's alleged that you assaulted Brandy Gillespie. Your lawyer indicates we're going to set this for a further pretrial. Is there a plea offer here?
The offer was a plea to domestic violence with a statutory deferral.
All right, that's what the note says. He's not willing to accept that at this time?
Not at this time, Your Honor.
All right, well, let's talk about this. You've got no contact provisions. Where are you staying?
I'm in Angola right now at my mom's house, but we have a hearing next week to have the the restraining order vacated. And she wrote into the prosecutor and everything, saying she didn't want charges pressed on me and a bunch of stuff that she sent my mother.
Well, that's very common. The people that are charging you are the state of Michigan.
Yeah.
Not Miss Gillespie, and so we'll see, but they'll certainly accept her input at the prosecutor's office. So what address are you using?
9978 West Myers Court, Angola.
All right, very good. The no contact provision stays in effect till further order of the court. Maybe we'll review it, but not right now. So we'll set several of these for a pretrial on a Thursday at 2. I'll see you in a couple of weeks. It'll be before the end of May.
Okay, does that mean like we have the hearing next week?
Just give me a call because it's a little more information.
Okay.
Yeah, just give me a call because I don't know if it's so that doesn't affect your bond conditions, even if the PPO is correct, your bond conditions. So just give me a call. Give me a call after that hearing. Let me know what happened before you have contact.
Stephen Davis. Good morning, Mr. Davis.
Good morning.
Are you working third shift? So you've been up all night? Like I said, you were sleeping, but you weren't causing any disturbance, so it is boring in here. It's been to me all day. You're charged with driving suspended, first offense. Prosecutor has agreed to reduce that to a charge of no valid operator's license. No valid operator's license is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. The good news is it doesn't carry any suspension, but it does carry 2 points. Do you understand?
Yes, sir.
You've acknowledged the advice of rights. Ms. Strong, is that your understanding of the plea agreement?
That is my understanding of the plea agreement, and I am also of the understanding that the prosecutor's office is recommending fines and costs for this. I know that Mr. Davis has some outstanding fines and costs. I believe that he set up a payment plan to get those taken care of. And he did that this morning, Your Honor.
Okay. Are you going to plead to driving with no valid operator's license?
Yes.
Were you driving a car in Sturgis at 10 o'clock at night on March 15th?
Yes.
Where were you going?
I was headed back to work because I forgot I had the work phone.
Where do you work?
I was working at Myers at the time.
All right. And was your license suspended?
Yes.
You owe $1,470 with unpaid fines and costs, including a previous driving without a license, 2 charges of allowing another to violate the motor vehicle code, and another no ops, plus some other stuff. And miraculously today, you set up a payment plan. So
I've actually had the payment plan set up. I just verified that I had the payment plan today.
well, you have the kind of payment plan where I want you to make a payment. I can wipe all that stuff out with a jail sentence. I don't want you to lose your job, but you've been blowing this stuff off. You keep getting charged with driving suspended, and the prosecutor keeps reducing it to either no ops or allowing another to violate the motor vehicle code. Then you blow off the fine, 2022, 2023, 2024, 2025. I'm going to set this for sentencing on a date that your lawyer is already here, June 3rd. 2026 at 10:30. I want you to pay on these. I don't want a $5 payment. I want you to make a significant payment, or I can. You're not pay it all off, but I want you to make some sincere effort to make a payment. If I had a clerk in here, I could have them give me the notice, but I don't. That's a Wednesday. They call that Casey Strong Day around here. All right, I'll see you on June 3rd and see how much you can pay on all that stuff between now and then.
Thanks, sir.
Curtis Kennedy. Good morning, sir. You're Curtis
Good morning.
Kennedy.
Yes, sir.
You're charged in several files here. 2565 SM with no insurance under the insurance code. Driving suspended in 2566. And improper display of plate in 2567. Prosecutor has offered that if you plead guilty to driving suspended, the other charges will all be dismissed. Is that correct, Ms. Strong?
That is correct, Your Honor.
The no insurance one is the big one. It's punishable by up to a year in jail and a fine of up to $500, not less than $200. So the minimum fine for that is $325. That's being dismissed. The plate charge could also cost another $200. But driving suspended is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. And it requires that your driver's license be suspended. So you're going to have your license suspended. Do you understand?
Yes, sir.
And that's always, not forever, but for a period of time. Other than the plea agreement here where this expensive stuff is dismissed, anybody promise you anything to get you to plead to this?
No, sir.
Please. All right, you're one of these guys that's got a bunch of real old baggage, which is causing your license to be suspended.
And like
The driver license appeal division of the Michigan Secretary of State has got a real long memory. You got some drunk driving charges from 20 years ago, which has caused you to be suspended, to be revoked. If you get 2 drunk drivings in a 7-year period, they revoke your license. You actually have 3. Then every couple of years, you get another driving suspended charge, which further puts you in a hole. You had one here in 06. You had a recent one at Cassopolis in 24, but you haven't had a ticket in St. Joe County in about 20 years. Where were you going this particular day?
This particular day, I actually just got done fixing a pickup truck that I was gonna sell since I'm not allowed to own a vehicle in the state of Michigan.
Well, I guess you can own one if you were a collector or something, but you
Right.
can't register it.
Can't register or nothing like that.
Later.
So I got this fixed up and a buddy stopped by to see it and his motorcycle wouldn't start back. So I threw it on the trailer I had there at the house and drove him to Constantine, which that was a mistake.
That was under the category of DUME at 10 o'clock at night. No plate, no insurance, no license. Did they take you to jail?
No, sir. He actually pulled me over 3 houses away from the destination I was going for no tail lights on the trailer.
I'll do that every time, if nothing else to tell you to get lights. All right, this was an expensive mistake. You are on the driving suspended merry-go-round big time.
Yeah, for 20-some years.
Yes, I tell young people, you're a prime example of it. You make some bonehead mistakes when you're young and then they carry you around like a millstone around your neck for the next 30 years.
Yes.
If you could talk to your younger self, you would say, hey, don't do this.
Yeah, well, trust me on that.
You had a driver that brought you here today, correct?
Yeah, oh yeah, she was right there. I know better than that, sir.
I know the rules.
All right. I'm not gonna order any jail, but there's a $125 fine, $125 of court costs, and a $150 attorney fee. That's $375. That's a lot. The other other charges are dismissed, which is gonna save you quite a bit of money. Can you pay that in 30 days, or you want me to put you on a payment plan?
Sir, I'd probably have to be put on a payment plan because I take care of a elderly lady. I actually stay with her and help take care of her property, her home for her.
All right, well, stop driving.
Yeah, I
You're
have.
just,
Okay. I get so many spam calls. That's why a lot of them might pick up because I get things.
all right, the court officer will take you out there to get set up on this payment.
If you don't hear from me,
All right, we're trying to get Casey done by 11. Let's see how we're doing. Samir Young,
Thank you, Your Honor.
that last one's okay.
all right.
Yes, Your Honor.
I think we're gonna make it.
Mr. Young, I met you before at your arraignment, but you're Jameer Young,
Yes, sir.
file 231446 SD. You're charged with operating while intoxicated. The prosecutor has also agreed to reduce this to a charge of impaired driving. Is that correct, Ms. Strong?
That is correct, Your Honor.
Good
And-
morning, sir. Welcome to
and-
our courtroom.
I just made the word working and I've never been
And-
up here, I'm a carpenter by trade. It's just.
Well, you're welcome to look around. You just need to take your hat off.
Oh, I'm sorry, sir, that's my mistake.
And Your Honor, it's my understanding, and
Yes, it is.
you can confirm from the statement that the refused PBT, which is count 2 on the complaint, is also being dismissed.
All right.
But it's not, no, it's not 11. It's noticed for 10:30. I had it on as 11. Thank you, Angelique.
Oh, she was required at 10:30?
Yes, but it's okay. We'll wait. She's almost.
I had it on at 11.
We were
I
shooting for
apologize.
11.
Yeah, that's what I had it set for, but.
All right. Mr. Young?
Yes, Your Honor.
Same question. Anybody threaten you to get you to plead to this charge?
No, Your Honor.
Promise you anything?
No, sir.
And you understand you're giving up all the rights on the advice of rights?
I do, sir, yes.
Let me find your case.
I'm trying to. I already gave it to him. I have one for the next one.
Oh, come on. Oh, 23, this is an old case.
Yeah, this is a citation from 2023.
Sorry. Sorry, it took me so long here. This wasn't in my queue. You're from Wabash, Indiana. Well, you're from somewhere in Indiana.
It'd be Converse, sir.
Converse,
Yes.
Indiana. We talked about that.
Not too far from Walmart.
Were you driving a car in Constantine, just outside of Constantine on 131 Observatory Road,
Yes,
July of 23?
yes.
And about 2:30 in the morning. Where were you going?
I was actually headed home,
From where?
Grand Rapids.
Well, it's a long way from Grand Rapids to Converse with that high of alcohol. What were you drinking?
Domestic,
Say it again.
domestic beer.
All right. How many?
Throughout that day, I would probably say maybe 11 12-ounce cans. Saturday afternoon.
What kind?
Bud Light.
What was the blood alcohol here, Ms. Strong?
0.152 grams per 100 milliliters of blood from an MSP laboratory report.
I think maybe you lost track because you're 2 times the legal limit. And Bud Light is relatively small in alcohol content, but I certainly understand why they're setting this for impaired. Ms. Strong, I've got reserved for June 3rd. We'll be busy that day, but we'll set this for June 3rd at 11. Might as well get our money's worth that day. This was old and they caught up on it and we'll get this resolved. This will restrict your license, at least for Michigan purposes. You've made every court appearance once we caught up with you again.
Understood.
So the court officer will take you out. They'll give you a notice to appear on June 3rd at 11 o'clock. Mr. Young, you're good to go.
Restitution, prosecutor does not have information about restitution, and will file a motion or request if restitution comes up.
All right, well, let's talk to Mr. Peters. He's in my sobriety court program right now. Good morning, Mr. Peters.
Good morning.
This was under my radar. You got a couple of drinking drivings right in the short sequence. I will tell you, Ms. Strong, Mr. Peters is a different man than if you'd met him a few months ago.
I heard that he's doing very well in
He
sobriety court.
is doing a lot better, but I don't like this much.
This happened, this was a while prior.
It's last August, so it's an old one. So it, I think, precedes the other stuff.
That's
Anyway, you got a ticket on August 11th for failing to stop after a collision with Amanda Speece. I don't know whether you were drinking that day or I don't know, but this case has been percolating around out there. Prosecutors agreed to dismiss that for a plea to a charge of allowing another to violate the motor vehicle code. This won't undo what we're trying to do in sobriety court. It will allow you to keep a restricted license, drive back and forth. Well, it would, in fact, it won't show up on your driving record at all. It's non-abstracted, do you understand? You have to speak your answer.
Yes.
Anybody threaten you to get you to plead to this?
No.
Or promise you anything?
No.
Were you driving a car that day, August 11th of 2025?
I honestly can't answer that.
All right, well, then we can do it as a no contest plea if you don't remember it. Will you allow or accept that you were in an accident that day and left the scene?
That's what they tell me.
My fear is this was a drunk driving case that got away, but we got a hold of him in the meantime, and he's in the program. Zero days in jail. I'm gonna waive your attorney fee, I'm gonna waive your fine, $125. It's gonna be part of probation and sobriety court. I'm gonna reserve on restitution. Address that.
Thank you, Your Honor.
How's this week been?
If you don't mind, I'm gonna put Judge Kane out of his misery.
Yeah, all right.
Thank you.
I thought you were a part of the circuit court.
It is circuit court, Judge Kane.
Oh, Judge Kane. I thought you said Judge. Okay, thanks. Which case are you doing?
Bond violation, a bond motion on Timothy Yoder.
Okay.
So pardon me.
Oh, we didn't do the no-show on Lonnie Williams.
Okay, you want me to just, I'll run back.
All right, when you're done. All right, let's call Paul's client. Hello, Deputy Judge Middleton calling. Could I see Patrick Jones in my courtroom? All right, thanks. Bye. Anyway, you've been stuck in here all morning watching everybody else's cases. As you saw, there's a lot of other drunk driving cases that come up each month. That may have been a bit of an eye opener for you.
It was.
We probably had 8 of them today. 0.3 blood alcohol, 0.299. A lot of people out there struggling. Anyway, I'm gonna make this as part of the payment plan on your probation, but right now you know you can't drive and you live right here in town.
No, I don't.
Oh,
I rode my bike from Traverse.
Oh, you did again?
Yeah.
All right. How you doing with your ID?
Excuse me?
How you doing getting your ID?
I got one more document. Medical records from the hospital.
Well, I'll see you on Tuesday and we'll talk
Yes, you
more
will.
about it. All right, you're good to
If
go.
it's not pouring down rain, I'll be here.
Well, we may need to do it remotely, although I wanted to do we have 2 graduations. Judge Pattison is gonna need this courtroom, but we'll see. Stay in contact with Priscilla.
Now, I've got my Zoom apparently working, so
All right,
either way.
I'll see you Tuesday.
Yep, thank you.
I don't know how good of a count I did. 11. I say if we get 13 pleas, we've done a pretty good day. I think this is number 12. I may have missed a couple. So Mr. Jones is gonna plead to one, retail fraud. Third, and it will resolve all cases, including the trespass.
That's my understanding.
Okay. I don't know how much jail credit he has.
Well, is there, well, trespass, I don't know if I have a information about a trespass. Was that, let's see, a city thing or
Yeah, it's a city case.
Because I guess I didn't talk to a city prosecutor, so I don't.
He's actually got 2 trespass. Maybe they forgot those.
Are those, is it Sturgis or Three Rivers? Sturgis, like it's Tim, that Tim is the press?
Yes, I'm sure he dismissed one to plea one.
I could try to call Tim really quick.
Yeah, why don't you?
Okay.
Good morning, Deputy Feaster.
Good morning, sir.
Nice to see you. Mr. Jones will be with you in just a moment.
Yes, sir.
It's good to see you too, sir.
Thank you. Mr. Jones, you've got a retail fraud case that we're going to address here in a moment, but you've also got a couple of trespass charges, and we're going to see if we can take care of those too. Hi, can you tell me, this is Judge Middleton again, how much jail credit Patrick Jones has? Thanks. Bye. I'm not sure what happened to those trespasses.
I was not able to reach Mr. George.
How about, you have Mr. Reed in your phone? Mr. Reed?
I don't have his phone number right now. I guess but I could try to call, I could look it up, I guess, his phone number. I'll try to call him real quick if you think we have time.
All right. Email. somehow they slip between the cracks. It's almost lunchtime. Any luck?
No, I guess they said that. I called Tim's cell phone and then she said Tim, and then at the office, I guess he's not in his office, so he may, and Attorney Reed, I guess, is not there today. So.
Well, all right, let's take care of what we can take care of. Mr. Jones, you have 2 retail fraud charges. File 251956SM alleges retail fraud in the 3rd degree allegedly occurred on September 8th of 2025. That is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. You're going to plead to that one. The other one is a retail fraud 2nd degree from Walmart from April 26th of 2025. That's punishable by up to a year in jail, and the prosecutor is going to dismiss that. Do you understand?
Yes, sir.
All right. And they want restitution of $254. Do you understand that?
Yes, sir.
Oops. Let's take a look at the case that's left. According to Mr. George, they will accept a plea to 1 trespass and dismiss the other. He just confirmed by email.
Oh, okay.
So we'll address that too.
I'm pretty sure that Mr. Jones would want to try to resolve all of his cases because.
So we'll talk about that too. All right, Mr. Jones, if you plead to these charges, you understand that you'll be giving up your right to have a trial in front of a judge or jury. There will not be a trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. If you could not afford an attorney, the county could appoint one for you at county expense. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, sir.
All right, this one is at the Myers store in September of 25. So let's take a look at the affidavit. They allege that you were at the Myers store and they previously told you not to come back. This was in Sturgis. And that you took a pair of earbuds and you admitted it, but you stuck them in another aisle. And then you walked out and had them under your armpit. Did you take a set of earbuds from Myers?
Yes, sir.
All right. Give me a minute. I'm going on a deep dive here to find a retail fraud. Fine. All right, you've been in jail for 9 days. Is there anything else keeping you there?
No, sir.
All right. Fine is 0. I'm waiving the attorney fee. You owe $254 in restitution. Walmart and Meyer.
Is that 250 a piece? 200, I'm sorry, sir. Is that 250 a piece?
$254. It also takes care of the case that was dismissed.
Is it 9 days jail then?
Yes, 9 days jail credit, 9 days.
Okay.
You also have 2 trespass cases from the city of Sturgis. This would make our 13th case. You're charged with trespass on December 11th of 2025, and you're charged with trespass on December 11th, 2 separate trespass cases. Under Sturgis ordinance, trespass is a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. They would offer to dismiss one of these if you plead to the other. Is that agreeable with you?
Yes, sir.
You have all the same rights I just went through a minute ago. And you understand that by pleading to this, you'll be giving those up.
Yes, sir. I wanted to point out that the trespassing it was to my residence that while I was staying there, and they condemned the place, so we had to move out, and they told me to come back and get our stuff. But I didn't know the exact time that I could come back and get my stuff, so every time I came back, it was like they was hitting me with trespassing.
All right, were you at a condemned house at 115 Jean Avenue in Sturgis?
Yeah, that's why I stayed at.
Well, Ms. Donna will take care of your case. You have some other unpaid retail fraud and trespass charges. If you get out of jail, where are you gonna go?
I stay 917 East West Street now in Sturgis.
All right, very good. Nine days jail credit, 9 days, leaving 0 days to serve. I'm gonna wipe out everything, but you'll $125 or 2 additional days in jail. I'm waiving your attorney fee also. So you're gonna sit in jail for 2 more days unless somebody will pay $125. I'm not generally supposed to do that, but I'm gonna not keep giving you fines that you don't pay. All right, Mr. Jones, you're good to go get lunch. I think Friday is prime rib day, so that should be pretty good.
So, you said I have 2 more days to sit in jail?
What's that?
You say I have how many? I got 2 more days to sit in jail?
If somebody bring you $125, you get out today, otherwise you got 2 more days to do.
So I get out Sunday?
Yes.
Okay, thank you. Thank you, sir.
Thank you, Mr. Gibson.
All right, thank you.
We have one last case. We try to save the Casey Strong cases for the last. Lonnie Williams. Lonnie Williams has $1,846 of unpaid fine and cost. I've known Lonnie since he was a kid. And most recently, some driving charges. He's not here. Did you have any contact with him?
I have not had any contact with him, Your Honor.
The charge here is a no valid operator's license, not the crime of the century. I'm going to do a $400 cash and surety bond with a 48-hour hold. Thank you, Casey, for your very busy day today.
Thank you for your flexibility. I had that on my calendar for 11 and I was incorrect. It was 10:30.
Well, we could have skipped ahead and taken Paul's cases and waited for you, but.
It was my mistake.
Okay. I'll see you on June 3rd, I guess.
I'll see you before then.
Okay, thank you. Well, I don't have any other files in front of me. All right, so we're going to take a recess. We are going to come back at 12:15 with a no lunch day for our swearing in. That will be a good thing to do on law day. And I'm very proud of Abby and we're lucky to have her there. So we'll see you at 12.
Others are the other 4 are to be dismissed, right?
Yes, sir. Those are repeated acts of 6.5, 6.6, and 6.7.
Okay, so 24 CR 6.8, 6.9, 7.0, 7.1, and 7.2.
That's correct.
Are to be dismissed. So there are 8 cases. He's pleaded to 3, 5 to be dismissed.
Yeah.
As part of this agreement.
Correct.
All of these allegations involve the same child. Correct, everybody?
Yes. That's correct, Judge.
The allegations in 65 and 66 and 67 are all similar. Causing the penetration of the sexual organ.
One is sexual organ to mouth, yes, sir.
Of the child. And on 6/5 and 6/6, these allegations occurred on or about the same date, April 7th, 2024. And one alleges contacting the mouth of the child with the defendant's sexual organ, and then the other, the sexual organ of the child with the defendant's sexual organ. And then finally, 2067 alleges penetration of the mouth of the child by the defendant's sexual organ on or about April 29th, 2024. Each of these are second-degree felonies, which carry with it the same punishment range, no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. The court will note a couple of things. Number one, the defendant's criminal history does not show any convictions at all, correct? Correct. And then the pre-sentence report and the probable cause affidavit show that the victim in this case is the same child who was 15 years of age at the time of the event. And according to the defendant's version, among other things in this pre-sentence report, it's summarized with, I stayed at the victim's house, and then the victim was in bed, so I made the decision to initiate the act. The victim was okay with it, so I followed through with the offense. Followed through the offense. I made the decision to move forward, commit the act, the process to lead to sexual intercourse. This is what the states. And then finally, it states it was consensual. That's your version?
That's what I read down, yes.
Mm-hmm. And then there is, even though no criminal history of convictions, we do have a serious substance abuse history that's listed here. Marijuana from, how old are you now?
37.
Okay, from the age of 12 to 10 years ago. So that would have been about 10 years in length. You say you used marijuana daily for a decade.
Yes.
That's true?
Yes, sir.
Cocaine, daily from 15 years of age until 10 years ago. So about 8 years.
Yes.
You're using cocaine daily.
Yes.
So marijuana daily, cocaine daily.
Yes, sir.
Then synthetic marijuana you used for a few months.
Yes, sir.
When you were 18.
Around that time, yes.
It says date of last use, 18 years of age.
Okay.
And then age at first use, 18.
Yes.
So and you reported that your primary drug of choice was cocaine, stating that you used the substances because, quotes, you didn't want to feel. I don't understand that. What does that mean?
The cocaine would numb any sort of emotional feelings. So I used it to kind of just medicate myself to, I guess, live. If that makes any sense. To just kind of medicate myself to try to be in an okay mood or happy mood. Is what I thought at the time.
Mm-hmm. According to the probation office, although the recommendations in the summary portion of this pre-sentence report states that although you reportedly took your full responsibility, your written and verbal statements minimize your conduct. You state, according to this, it was highlighted, you initiated the act and that the victim was okay with it. And that you described the behavior as consensual, which is what jumped out from my highlighting that I read in that, because all of that is inconsistent with the law.
Yes, sir.
It's not the way the law works. And also, it goes on to state that investigators recovered text messages in which you acknowledged the victim's age and made statements that could be interpreted as attempts to influence or manipulate her. I'm not sure what that really means. I tried to figure out what that was in all of this. Can anybody elucidate that for me? I don't understand. What did you mean by that, sir?
I'm not sure what it's referring to.
I think it's just referring to the communication between he and her in the sense that opened up activity for future dates.
All right. Are there any objections to this pre-sentence report?
No.
And then it is, again, made a part of the record for all purposes. Is it clear to you that a 15-year-old cannot consent to sex with someone your age?
Yes, sir.
When did that become clear to you? Because it obviously wasn't clear to you when this pre-sentence report was prepared, which wasn't that long ago. I mean, these responses are really flippant.
Yes.
It's ignorant to the law, but it's casual. I mean, do you understand this child is a victim?
Yes, sir.
To you, of you.
Yes.
No matter what the child may have been willing to do, they cannot consent to this legally because she's a child and you're the adult. The relationship of you to the child is what?
I was friends with her mother. We were all in a fellowship group, which was 12 steps over.
And I see these indictments range from in April of 2024. How long of a period of time did this actually occur?
It was just around that time.
A few months, right?
Months.
It wasn't long. I couldn't tell you exact time. But it wasn't maybe 2 months, 3 months. It was very short.
How did all of this end? Was it reported? Did the police get involved and that's what stopped it?
Someone saw some messages that I think a diary
It was a
that
diary.
the victim was writing, and they reported it to her parents or an adult.
Okay. In each of these cases, an agreement has been reached that whatever sentence shall not exceed a cap of 15 years confinement in prison. So in each of these cases, there are options. You would be looking at no less than 2, no more than 15 years confinement in prison. You could be placed, is deferred or unadjudicated probation an option?
Deferred.
But not regular probation, but deferred is.
Yes.
Is that what the state agrees with and understands?
Yes, sir.
All right. State can open and close.
Judge, all 3 of these cases are second-degree felonies, with the punishment being 2 years with a max of 20 years.
By the way, the agreement is whatever sentences shall run concurrently?
That's correct.
Okay.
Because the defendant does acknowledge the fact that he engaged in these offenses, that's why the state agreed to the cap. Also, on the flip side of that, when I look at the fact that the defendant does minimize and then he thinks that it was consensual, although the max is 20, that's why the cap is still up there at 15. So the state is going to ask that the court sentence the defendant to 15 years in the Texas Department of Criminal Justice. And I'm looking at the facts of this case alone and how the defendant thinks that he was having repeated acts of consensual sex with a 15-year-old while he was supposed to be friends with her mother in a recovery center, recovering from the drug acts, and then he's victimizing a child on the other side of that. So the state is asking for the 15 years TDC.
Mr. Jeffries, go ahead on your one.
Yes, Your Honor. So, Mr. Zambrano is here. He's pled guilty. He's taken responsibility. I understand the concerns about the statement that was made in the PSI, but I would say that Mr. Zambrano made those statements not saying that he's thinking she was giving permission, but that there was no physical coercion involved in it. The consent was not of legal consent, but of just lack of resistance, if you will. And that's not okay. And he understands the legal consequences of that. That's not disputing, and very much part of the reason we pled guilty to everything. Taking responsibility. The PSI also indicates that he would be a low risk should probation be an option. They've listed many conditions that he would have to comply with. I believe there was 31 of them. He has a clear criminal history. And this is a cap of 15 years.
Okay, we need, just for the record, so that's our, he has no criminal history. He's cleared of any criminal history.
Correct.
Okay.
Yeah. And the prison sentence that we're looking at is in between 2 and 15 years. If we look at the high end of that and say 15 is where we land, and he's going to come out of prison as a 48-year-old. He's going to come out of prison, detached from society, with a fractured view on everything, trying to reintegrate. That's still a fairly young individual trying to find his way into our community. And the question is, do we want that coming out of prison at that stage when we have an opportunity to rehabilitate through programming, through guidance, through steps that are available in community supervision situations? Part of the packet which has been turned over to the court is multiple reference letters, many of which are from his church where he's taking part in recovery programming, which involves him taking responsibility and discussing publicly his shortcomings and his crimes and his behavior, which has led to this point, and taking true steps to correct himself. He understands that this is punishment and it's warranted. And prison is very much on the table as a punishment. But we all know that probation is also a punishment.
Law says it is.
And in this situation with this type of crime, his punishment's going to last well beyond whether we put him on probation or whether we put him in prison, because he's going to be labeled sex offender and treated as such through society from now moving forward. We are asking the court that you take all that into consideration when making your decision, and just give him an opportunity to grow and be a citizen and correct his behavior and live out his punishment in a way that gives us a 48-year-old person who is in tune with society and ready to take a decent role in life moving forward.
Judge, it's not about what position we're putting the defendant in. The defendant put himself in this position when he made these choices in 2024. Yes, probation, in that report, it says low risk. That conclusion is based off of things that came out of the defendant's mouth. And the fact that he doesn't have a criminal history just says you haven't been convicted or caught with anything else, but his actions are so concerning that I don't think that his actions warrant us to send him back out into the community. And defense counsel talked about programs and placing him into programs. If we look at the facts of this case, that's how we got this victim here, is because he was in a program that was designed to help him deal with his drug addiction, and he victimized someone else in that program. So I'm very cautious about sending him back into the community and putting him back in the face of programs where he has the option to victimize other kids. And when you have an attraction to kids, or you don't know how to say no to sexual acts with kids, it's hard to say we're going to put you in a program and reprogram your brain to say you don't have that attraction. So again, the state is asking for that 15-year prison sentence.
Something that is curious that I don't understand on this substance abuse history. Just states that you were using marijuana from 12 years of age, cocaine from 15 years of age, and the date of last, and the frequency became daily. And the last date of last use was 2016. Is that true?
Yes, sir.
Okay. So that's 8 years before these events, correct? That's what this is on. These sexual assaults of the child occurred on or about April 29, 2024, April of 2024. So you quit using drugs, according to your statements, 8 years before these events.
Yes, sir.
Okay. And then the synthetic marijuana was last used when you were 18 years of age. So you're 33?
Yes, sir.
Well, that would have been 15 years ago.
Yes, sir.
You can't say that the drugs caused you to do this, can you?
No, sir.
Oh, that wouldn't be an excuse anyway. Well, somebody slipped you the drugs, because voluntary use of illegal drugs is not an excuse for committing crimes. But I'm going to give you an opportunity to say whatever you want to say if you wish.
Yeah, thank you. I only stated that it was consensual. I was just trying to be as honest as possible.
A child cannot give a consent by law.
And I'm aware of that now, and I apologize. I didn't mean to say it in that manner. I just wanted to state that I wasn't forcing myself upon anybody. Regardless, I do understand that she is underage, and I carry that.
Yeah. Most of the sexual assaults of children in this room over 20 years, and me as a lawyer, they didn't occur in an environment where they were placed seemingly under duress, which is because children can be manipulated. And their decisions are they're still learning. You, however, you were an adult.
Yes.
You had the responsibility to show self-restraint, which you didn't do.
And you are correct. I didn't do that. I couldn't talk about it at the time. It was very difficult to open up about that or even remove myself. And unfortunately, once this happened, it came to life. Of course, everybody went away, and at that point, I needed help, and I reached out, and that brought me to church. It brought me to people who have accepted me.
You've never been to church before?
No, sir.
Never in your life?
As maybe visiting with other people, but to actually practice.
What was it about having sex with a child that you thought wasn't contemptuous or wasn't sinful or wasn't illegal?
It was all of that.
It was?
Yes, sir.
Okay. But if you knew better, why didn't you act correctly?
At that moment, I decided to follow my urges.
All right.
If I'm being honest.
Yeah, well, that's a good thing to do.
And so when I went to these people from the church, I came with all that shame because I was tired of not being able to.
When did the shame come across?
The shame has always been there.
You mean when you were committing the acts?
With just any sort of sexual act that wasn't, and at the time I didn't really understand it, but I just felt like sex was always something that bugged me, probably due to being exposed to it as a kid. I was very confused. I didn't understand what was okay.
Wait, you thought putting your penis in a child's mouth was okay?
No, sir.
Well, that's what you're accused of doing and what you pleaded guilty to.
Yes,
and
sir.
then placing your penis into the child's vagina.
It's not okay.
Well, you knew that at the time?
Yes, sir.
Look, every case comes before this court, and we have to weigh how serious the circumstances are. All right. And let me just ask you this. How important is the innocence of a child?
Important. To the utmost.
Just important?
The utmost.
Well, you took that away.
Yes, sir.
From this child. There's no greater thing for a child than to lose her innocence. Unless it's her mind. First consensual act of a sexual act should be at an appropriate age and with someone who she loves and they're in love with her. And there is no force but intimacy. You made this whole act ugly.
Yes, sir.
Which is the gift that our Creator gave so that we could procreate, continue to exist on and on, generations. What? You seem to understand it and appreciate the seriousness. I don't understand why it took you so long. Why you didn't appreciate it at this time, during this, when this was occurring and the child was being victimized for the rest of her life. I just wish somebody, me or your attorney or somebody would have appeared right before you were about to make this stupid mistake, foolish mistake, harmful mistake, and try to make some sense out of all of this for you so that you made the right choice. That's what I wish, but we can't do that. We got to deal with what happened and go from there. You know, each of these crimes are separate events. Each of these carry their own punishment range. You're looking at really 60 years in prison. Your attorney has been able to fashion not only an agreement where all of these cases, whatever, number one, it's now limited. It doesn't have a possible maximum length of time. It's less than that. It's up to 15 years in prison. And all of those would be not added separately, but would be running concurrent. Plus 5 cases, 5 other crimes alleged against you would be dismissed. Okay. And each of these offenses are separate acts which could have run concurrently on top of each other, which would have certainly added up to several lifetimes. Well, Mr. Jeffries, a good lawyer, knows how to handle problems. And he does it responsibly. All right. Anybody else want to add anything, please?
Nothing further from the state, Judge.
All right.
All right. If nothing further, I'm going to find in each of these cases, that's cause numbers 24 CR 2065, 2066, and 2067, as Mr. Zambrano, Alberto Zambrano, you were charged with the second-degree felonies of sexual assault of a child in each case, a child younger than 17 years of age, namely 15 years of age. You pleaded guilty in each of these cases voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each of these cases, which was your confession of and understanding of rights, admitting to guilt. I now find you guilty beyond a reasonable doubt in each of these 3 cases. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 15 years in each of these cases. These will run concurrently. You must now register as a sex offender, and I believe this will be required of you for your lifetime. Two things. I wish, number one, you didn't do this. Somebody could have, you would have realized the right choice. But number two, you were grown up, you knew better. I am more sorry and feel sad for the child and what that child has to live with the rest of her life. A loss of innocence. Her first sexual experience shouldn't have been forced like this. It was inappropriate. It was illegal, and it carries with it severe sanctions. Anything else to add?
Nothing further from the state, Judge.
We are in recess. You were taken into custody, sir. I will dismiss those other 5 cases. You need to leave the room. You need to leave or you will be held in contempt of court. Thank you, please. maybe the worst type of crime that we deal with. It's my capital murders that I've handled, sexual assaults of children. I wish didn't exist, but they do. And we've got to deal with that responsibly and understand and appreciate the harm that occurs so that when it happens, it is dealt with severely. But there needs to be deterrence. Needs to be, this act is the most terrible act and lasts forever for the victim and the defendant. I have Christopher Barajas.